All right, folks, we're going to get started here as people are trickling in. It is another glorious Tuesday. Welcome to another Coffee Chats with the Economic Alliance Snohomish County. I am Gary Clark, President and CEO of Economic Alliance Snohomish County, coming to you with another Coffee Chats opportunity. So let's get started here as folks are coming in. Remember, we advocate, develop, and connect. Housekeeping. All right, so today we want to make sure that we add our organization names to our actual name on the chat so we know who we're speaking to when we engage with questions. And then last but not least, let's make sure that we are engaged. This is going to be a great opportunity to ask some questions throughout. And so please don't feel free, or actually feel free, excuse me, to join us. And I'll probably sift through those questions and make sure that Jordan is allowed to have time to give a presentation within a timely manner. So with that being said, let's engage. Here to speak today for EASC and our Coffee Chats opportunity is none other than Attorney Jordan Stevens with Anderson Hunt Law Firm. And Jordan is actually the chair of Anderson Hunt Law Firm's Employment Practices Division. And Jordan is going to actually give us some information on local business and municipal efforts, but Jordan also serves as the Employment Law Counsel for the local businesses and municipalities. Jordan, welcome to Economic Alliance Snohomish County's Coffee Chats. Please take it away.
Thank you. Let me just get my presentation mode. I am not super great at Zoom. Can you see the nice presentation without my notes and all that? Great.
It looks fantastic.
All right, good. Thank you. Well, thanks for the introduction. I'm happy to be here. I see a lot of faces I recognize from the community and working, and a lot of new faces as well. So it's nice to see and meet all of you. This training is primarily geared towards people who work for companies that don't have their own in-house person who specializes in human resources, or it's also really directed towards folks who maybe you have that in-house person, but you personally are not working regularly in HR or familiar with HR laws. This is sort of a 101 type training. That being said, if you are well-versed in HR, I'd love to have you stay on and take your questions, even if they're a little more complex or more of a deep dive into this topic, because I think that would be a really great component of this conversation as well. In this training, after the end, you'll get a copy of the PowerPoints. You'll also get a checklist that sort of highlights for you what areas that we'll be talking about today, what are some of the key elements that you need to just take away and go through mentally, or the physical checklist itself to make sure you're checking all those boxes. We'll just skip the introduction. Gary gave a nice introduction. Thank you. There are so many areas. I wish I could just do, an HR 101 full day training where I could just teach you the basics of every component of employment law. And I can't do that today in 1 hour. So what I'm doing is hitting the most frequent areas of liability that I see, although there are a lot of others. And that's hiring, rules about hiring, rules about how you classify workers, basics on discrimination and disability law, and also leave benefits. Wouldn't be a legal training if there wasn't some sort of disclosure as part of it. This training is informational only. It's not actually giving you legal advice. That being said, if you have questions, I'm happy to do my best to answer them, and also happy to talk to anyone after the training today. So We will start with hiring. Two elements that we'll talk about. First, our applicant inquiries. What can you ask people who are applying for a job with you? And then we'll also talk about what type of restrictive covenants you can ask or require employees to enter into. First is somewhat new. It was effective in 2018, I believe, the ban the box legislation that RCW is cited there, 4994. This law states that most employers, I'll talk about the exemptions in a minute, may not advertise positions as, no felons allowed or no one with a criminal background allowed. You may not inquire about someone's criminal history until after you've determined that the applicant is otherwise qualified for the job. It's this relatively new statute, so case law on what that means. What does it mean to determine that an applicant, get to the point where you've determined that an applicant is qualified is still to be determined. But certainly if you use application forms still and you have a box on there that says, do you have a criminal history? Or if you have a policy or it's in your job advertisement that you don't hire people with criminal backgrounds, that would violate this ban the box law, and you need to revise those practices. There are some employers who are exempt. Those would be employers who are posting for a position that will involve unsupervised access to children, vulnerable adults, vulnerable people, Washington law enforcement or criminal justice agencies, banks, and certain other employers. For the most part, this is going to apply to all employers. Another statute that is quite old, it was passed in 1943, the Equal Pay Opportunity Act, but it was not amended, first amended until 2018, so almost 75 years later, is the Equal Pay Opportunity Act. The purpose of that law was to provide, was primarily focused on gender pay disparity, although it applies to racial or any other paid disparity that may exist. The update in 2018 really expanded the Equal Pay Opportunity Act and its coverage, and it was based, the desire to do that in 2018 was based in part on some studies. We've probably all seen these types of statistics quoted, but for every $1 made by their white male counterparts, it was found that white women make 79 cents, Black women make 63 cents, Native American women make 57 cents, Latina women 54 cents. Asian women made 87 cents. However, there were subgroups of Asian women that were extremely low. Vietnamese at 65 cents to the dollar and Pacific Islander at 59 cents to the dollar. So to address the pay disparity, the Equal Pay Opportunity Act, the Equal Pay Opportunity Act was given a lot more meat. And it states that similarly employed individuals must be paid equally. Similarly employed, what does that mean? It means that they perform jobs that require a similar skill, similar effort and responsibility. You cannot rely on an employee's previous wage or salary in determining what their current salary will be or in determining what you'll offer them for their current salary. But there are some acceptable reasons for difference in pay. That would be differences in education, training, experience, seniority, and merit. Those are certainly acceptable reasons. If you measure earnings by production quantity or quality, that's deemed appropriate. Regional differences in compensation are also appropriate to take into account. There are also a couple of other requirements in the amended Equal Pay Opportunity Act. If the applicant requests, the employer must provide minimum wage information or salary information for the position that they're applying. And that applies to your someone who's applying for who's new to your company applying to a position, but it also applies if you have an employee who is a current employee and they're transferring to a new position. They can ask about salary information, salary scale information, and you're obligated to provide it. Employers also cannot prohibit employees from disclosing their wages and cannot take negative action against an employee for discussing their wages or exercising those other rights. All right, we'll talk about restrictive covenants now. Restrictive covenants that are used, most commonly used for employees are non-compete agreements, non-solicitation agreements, and non-disclosure agreements. A couple years ago, the state legislature passed a non-compete agreement law that provided a lot of clarity for employers. It basically stated that non-compete agreements, which are agreements that restrict a person from working or engaging in a particular trade, are unenforceable as a general rule. There are some exceptions. So for example, if you're hiring a salesperson to come on board, you want them to sign a non-compete agreement, perhaps that says, when I no longer work for you, I agree that I will not be employed by any of your competitors. So those types of agreements are unenforceable unless there's valid consideration given. So you have to give something in exchange for that valuable agreement that they're giving you. It might be cash, it might be a job offer. Now you might say, we are not going to hire you. This employment offer is contingent on you accepting this and signing this agreement not to compete. So there must be something valuable given in exchange for that commitment from them. They also must earn at least $101,400 annually, and that amount increases slightly each year. So if you have an employee who's making less than that, even if you give them valid consideration, if they don't make that $101,000, it will be deemed invalid. There are also other restrictions that are not in the statute, but courts often impose. Examples are if the non-compete agreement is too wide, if it's too great in scope, which would be it covers too broad of an area. Somewhere where, like Snohomish County, where we're very dense. We've got a lot of businesses in a small amount of area. And so a non-compete agreement that's getting beyond 5 or 10 miles in scope might be deemed invalid, for example. The statute also states that if you lay off an employee who signed a non-compete, you cannot enforce that non-compete unless you pay them their earnings that they have given up because they are laid off for the period of enforcement. So non-compete agreements always have a length. The statute presumes that 18 months is an appropriate length for a non-compete, so 18 months after they're employed with you. So if they get a new job that follows, but they employment with you, but they make less money, you would be required to compensate them for the difference in order for the non-compete to be enforceable. Other types of restrictive covenants that don't have those types of qualifications, except for valid consideration, you always have to give valid consideration, whether that's the actual job offer contingent on their acceptance of the their agreement to the non-solicitation or non-disclosure covenant, or it's cash. So that is required, but all of those other provisions that are required in non-compete agreements are not required in non-solicitation and non-disclosure agreements. And so in light of the law, I find myself frequently advising clients to consider pursuing instead non-solicitation or non-disclosure. What non-solicitation does is it states that you may not actively solicit our clients or our vendors away from us after you leave employment here. So they can't go and poach your clients from you. Your clients still have freedom to change who they work with, but it restricts the employee from poaching.
Hey, Jordan,
Yeah.
a quick question here that's tied to your slide here from Robert Logan, technology porter. Just a question on the salary or the annual earnings that you have listed here. He asked, does that include benefits, healthcare, employer pays, or is that just a base for the annual earnings?
If it's a cash benefit, then it might be included in the definition of earnings. But if it's just the fact that you provide paid time off or you provide medical insurance, that would not qualify as earnings. Good question. In non-disclosure agreements, what those do, those are confidentiality agreements. Basically, it says when you leave, you agree you will keep our pricing strategy, our whatever it might be that you want to keep confidential, that you will keep that confidential. So again, nothing required in exchange for that other than valid consideration. All right, so now you've hired the worker, you've got some employees. What are some other possible or likely areas of liability? There's two main decisions you have in how you're going to classify the worker. First, are they an employee or an independent contractor? And second, are they exempt or non-exempt? So let's first talk about what does it mean to be an employee or a contractor? It matters what that decision that you make, whether they are an employee or contractor, matters because of all of these things you see on the screen. You have very different requirements if someone's an employee than if they are an independent contractor. Tax liability and overtime pay are probably the biggest financial areas of a liability for you if you misclassify someone. Also, just because you say, okay, this person's an independent contractor, that's how I've got it on my books, that's how I put it in our agreement, does not make them a contractor. What makes them a contractor is how these 6 factors that we're about to discuss, how the worker falls in the totality, considering the totality of these factors. The first one, which is probably given the most weight by courts, and sorry, there's a lot of words on this screen, is whether the worker is free from your supervision, direction, and control. So an independent contractor, someone who truly qualifies as an independent contractor, would be someone who you're not concerned with how they perform their work. All you're concerned about is their final work product. You're not concerned about the specific individuals who are performing the work. You've hired the contractor. It might be a company that has multiple employees. You let them figure out how they're going to get the job done, who's going to do it. You don't provide their training and equipment. Also, if you don't contract with multiple individuals to perform the same work, which would then require them to coordinate, that will also lean in favor of them being designated an independent contractor. And you don't necessarily need all of these bullet points, and you definitely don't need all of these 6 factors, but the more you have, the stronger your case for an independent contractor will be. An employee is someone who is going to work in your office, most likely. There are exceptions to that. Like I said, it's a factors analysis. If you got someone who works from home or their own separate office, it doesn't necessarily mean they're not an employee, but if they work in your office, they're sure going to look like an employee and not a contractor. You set their hours, you keep their timesheets, you pay them on a regular paycheck cycle, as opposed to paying them on your invoice cycle. You have the ability to hire and fire them. I could say a lot more, but I'll just stop there for now. Second factor, is the worker's business different and separate from yours? Is it outside the usual course of your business? For example, let's say you own a hardware shop and you hire someone once a month to come and clean your windows. Well, you run a hardware shop. Your job isn't to, you're not performing the service of cleaning windows for people. You're selling products. So what the window cleaning folks are doing is outside the course of your usual business. They're going to look a lot more like an independent contractor than an employee. Third, does the worker have an established business? Do they have an independent business that they've established? Do they have a tax return that they file in their business's name? You can actually require, and you may want to, because you're the one who'll have liability. The contractor or employee may have some liability, but you'll also have some tax liability. So you may want to require them to commit to you or to provide you a copy of their tax return, or that they commit, acknowledge in the contract that they are an independent business and that they will indemnify you if the IRS or a court were to determine that they're actually an employee and not a contractor. And kind of along those lines, here's 3 additional factors, the last 3 of the 6 that go into a court considering whether someone is a contractor or an employee. Are they required to file a set schedule of expenses with the IRS? Do they have all their required registrations and licenses? Does the individual maintain their own set of books and records? Again, I think I touched on this bottom point already. You can actually ask for a copy of some of these if you like, and you could just let them know, I'm not trying to be a busybody. I'm just doing my due diligence to make sure I'm not going to be liable in the future. So let's do a couple of quizzes, pop quizzes, to talk through some of this. Okay. So business enters into a 3-month contract with an independent engineer to bolster their own staff to meet a big deadline. The engineer works at the business's site along with the business's employees, coordinated by the business's project manager. Do you think this would be an employee or a contractor? I don't know, Gary, if just typing it in the chat might be the best way if you could type your answer. I can't even see the chat right now, so I won't know who's right or wrong.
Dana said employee from downtown Everett, and yeah, you're getting a lot of a couple of responses that say employee.
Great. Yep, that's absolutely right. This person more likely than not is going to be deemed an employee. Okay. Similar situation. Business enters into a 3-month contract with an independent engineer to bring his own specialty to a particular project. The engineer works from his home office. The engineer has a final deadline date and communicates with the project manager once a week, providing updates on his status. That's employee or contractor. It's kind of a
quick responses coming in as contractor.
Good. Yep. So things that make this person look a lot more like a contractor than the last one. They're bringing their own specialty. You don't have this type of specialty already. If you do have this specialty already, in like the last example, you're really just needing some more hands on deck because you're going through a busy season. It's going to look more like an employee, but this guy's bringing his own specialty. He works from home. He is providing updates once a week, and that's, not necessarily suggesting that he's an employee, but it sounds like he's pretty free kind of to manage his own schedule to get to whatever the final project is. So he's definitely going to be designated a contractor. All right, independent fitness trainer works at your fitness center. She maintains her own client list, but she's required to wear clothing with your gym's logo on it and required to charge a standard rate. Is she going to be an employee or a contractor?
I feel like we need some music here. Employee from Dana, contractor from Jane. So got a mixed response here so far.
Yeah. Just wait a minute, see if anyone else. This is
Employee,
trickier than the last one.
Minor says, Harris says employee, Cherie says need more information.
Yeah. Yeah, more information would be helpful for sure. This is a gray one. I think it is most likely that she would be deemed an employee. If she was just wearing the gym's shirt, but all the other factors indicated that she was a contractor, then I would say, you know, I think if this person were my client, this business was my client, I'd say, you know, I think you're okay on the contractor. You can have her wear your logo, but just make sure, you know, everything else she does fits the contractor test. But in this case, the fact that the gym sets her rates is really going to make her look a lot more like an employee. That's a pretty significant factor that will weigh in favor of her being deemed an employee. Now, if she does all these things, she coordinates her appointments, she wears an outfit of her own choosing, she maintains her own client list and sets her own rates. Those are factors that would help her look a lot more like a contractor. All right, last little fact pattern. You own a small private school. You enter into a contract with various individuals to teach one subject 3 times a week for 1 hour each. Are they an employee or a contractor? I think this one's might be the trickiest of all of them.
All right, we've got one for employee. And then we got another for employee. All right.
Yeah.
And one for contractor. And so you have about 4 for employee, 1 for contractor.
Okay.
2 for contractor.
This is very common because they feel like a contractor. I see this a lot. They feel like a contractor because their role is just so limited. They're only working, in this case, 3 times a week for 1 hour. So they're working 3 hours a week, maybe a little more with some prep time, of course. They're just teaching one subject. They're not full-time. So in a common response would be that they are a contractor. But in this case, that would be incorrect. They would be an employee because this is the essence of your business. You run a small private school. If your teachers are not employees, then no one's an employee. That's the most fundamental component of your business. So if we think back to that example of you run a hardware shop and you bring someone in to clean the windows once a month, that's totally outside the scope of what you do regularly in the ordinary course of business. So they would be a contractor. In this situation, falls within the course of your business. This is an essential employee that you need to keep your business running. So they would be deemed an employee rather than a contractor. And the same example, but you contract with a company to provide janitorial services, that would fall into a contractor example. All right, so next and last type of employee classification that we'll talk about is whether someone, an employee, so we're just talking about employees here, not contractors, whether they are deemed exempt or non-exempt. We'll talk a little bit more about what that means, but this is referring to the FLSA, the Fair Labor Standards Act, which is a federal law, and the MWA, the Minimum Wage Act, which is the state component of that. So as a general rule, under the FLSA and the Minimum Wage Act, employers must pay employees overtime at 1.5 times the regular rate of pay for all time worked in excess of 40 hours per week. We could have a whole session just on what is a week. So I could take an hour just talking about that. I'm not going to, but just so you know, there's a lot of components in this. And so if you ever run into something you're not certain about, especially when it comes to the Fair Labor Standards Act, that's a time when it's worth picking up your phone to talk to your attorney about it. So the exception to the overtime rule is if an employee is exempt, or if they're not an employee. If they're a contractor, don't got to worry about it. But if they are an exempt employee, that's another situation where you don't have to worry about tracking their hours. You don't have to worry about paying them overtime. So what are different types of exempt employees? This is a list of the most common. There's a few others, but these are the most common types of exempt employees. The most common out of these are the ones that I've bolded: the white collar employees and highly compensated employees. I'm going to talk just about white collar employees because those are the most common types of exempt employees. And there's 3 types of white collar employees: executive, administrative, and professional. So how do you know if an employee is an executive, administrative, or professional employee that would exempt them from the FLSA? There's 2 tests to determine if someone's a white collar employee. There's a salary basis test. That's the same regardless of whether they're executive, administrative, or professional. The salary basis test is the same. And then there's a duties test. The duties test is different for each of those employees, and we'll walk through both of them. So the salary basis test says that in each pay period, the employee must receive a predetermined amount of compensation regardless of how many hours they put in. So their salary, their wages that they receive cannot be subject to reduction because of variations in quality or quantity. We'll talk a little bit more about that. So first, what dollar amount do they need to receive each week to qualify? If you're a small business, they need to make at least $821 a week, or $42,713 a year. That amount is increasing each year. It's 1.5 times the minimum wage. And so that will increase it each year until like 2028. And then there's a new way that it's calculated. So go to the L&I webpage, Washington State Department of Labor and Industries. In the fall of every year, I forget which month it is, but they announce what the upcoming minimum threshold, it's called a salary threshold, is for the upcoming year. Large businesses, that dollar amount's $958 a week, or just shy of $50,000 a year.
Hey, Jordan, there was a question about whether or not that was net or gross.
Gross.
Thank you.
Good question. Is there this red mark on your screen? Can you see that?
Yeah,
line?
yeah, it popped up maybe
Did I do that?
4 slides ago. Yeah, I think you might have touched the screen in it.
Okay.
Yeah.
I'm using 2 screens, which is handy, but it's also, let me just take 10 seconds to see if I can get rid of it. If not, we'll just keep on going.
Honestly, Jordan, it added some
Eraser.
mystery to the presentation. So
What's
I
that
took it off for
for?
you, Jordan.
Okay, did it come off?
yes.
Okay, thank you. Okay, so let's talk a little bit more about what that means to receive the same salary, the same wages every week. So they have to receive the same amount every week, regardless of whether they work 8 hours or 40 hours in a week. If they put in 1 hour that week, you need to pay them for the full week. So there are some exceptions. I'm going to go through these quickly. If the employee is absent for 1 or more full days for personal reasons, then you can make a deduction for the full days that they were absent. But if they worked 1 hour in a day, you need to pay them for the full 8 hours. There is an exception there for public employers if they've got some sort of, which everyone does, some sort of paid time off program, then they can do partial day deductions, but that doesn't apply to private employers. If an employee is absent for 1 or more full days because of a sickness or disability and the deductions made as part of a bona fide sick leave program, then you can do the deduction. And everyone here, because we're in Washington State, we have the paid sick leave law that would apply to all of you here, presuming you're providing paid sick leave as required by law. Unpaid disciplinary suspensions, FMLA leave, those are some situations where you can do partial day deductions. Also, for the first work week that they work and their final work week that the employee works, they can you can pay them partial days. There we go. If the absence is occasioned by the employer, which means the employee says, hey, I'm ready, willing to, able to work, you don't have work for me, or you've chosen to close the office, then you, for salary employees, for non-exempt, for exempt workers, you must pay them for that day. This comes up the most often in snow days. So you close your business because people can't access your business. Your hourly employees who are non-exempt, you don't need to pay them. Non-exempt workers, you pay them for the hours they work. But for salary workers, if they were ready, willing, and able to work, but you had to shut your business down for the day, then you are required to still pay them. I do have employers who want to try to get around that sometimes on snow days by saying, well, I know that the employee was not able to work because I know where they live. They couldn't have gotten to work successfully. If you want to try to, it's unlikely that situation would end up in court if you chose not to pay them, but the burden would be on you to prove that they were not ready, willing, and able to work. So sometimes it's just worth not fighting that. And now we have so many employers have the ability to have employees work from home. So this may be less of an issue, I think, because of COVID for our future snow days. Okay, so that's all we'll talk about on the salary basis test, step number 1. Step number 2 is the duties. All right, so you've got someone, they meet that salary threshold, you pay them accordingly, but we also need to look at the substance of what they do. Are they an executive, an administrative, or a professional? So executive, this is someone who's generally responsible for the success or failure of the business. Look at their job description and their job duties that they're doing on a regular basis. Is management one of their primary duties? Do they supervise the work of 2 or more employees? And does the employee have to all 3 of these? And does the employee have the authority to hire, fire, or promote? And if they don't have the authority, someone else does, but they at least have a significant input in that process, then they'll meet the executive test. All right, so you have an employee, they meet the salary threshold, but they don't fit into these executive elements. Let's look next at administrative element. Is the performance of office or non-manual work directly related, the work that they're performing, is it directly related to business operations? Is their primary duty office work? And so you have to have both of these. Their primary duty includes an exercise of discretion and independent judgment with respect to matters of significance. There's a lot of employees who meet element 1, but don't meet element 2. So factors that weigh into element 2, what's the relative importance of their duties as compared with other types of duties in your organization? What's the frequency with which they exercise their discretion? Do they have a relative amount of freedom from supervision? Examples of employees who do meet this administrative duties test would be an insurance claims adjuster, team leaders, an office manager who also has some bookkeeper duties. Generally, someone who just has bookkeeper duties would not meet the duties test, but if they also have office manager skills, which is a really common pairing, then they would. A field engineer, administrative assistants. Sometimes what you should do is really distinguish between your higher level administrative assistants as opposed to receptionists. Make sure that's clear in job descriptions and in their actual duties, in which case you'll likely meet the administrative test. Third option, if they're not an executive, they're not administrative, they could qualify under the learned professional exemption. These are the types of individuals who have some really specialized training and knowledge: accountants, engineers, lawyers, doctors, registered nurses, generally not medical assistants or nurses aides or LPNs, but registered nurses are, pharmacists, certain types of creative arts employees. If the person is still in a trainee status, they're not going to qualify for the learned professional. They need to have achieved that training and experience. All right. Any questions before we jump into a totally other topic? Okay. Discrimination. This is another component, another place where we see perhaps the most amount of claims. Employers have the most risk of getting a discrimination claim once you have an employee hired on. You can also get discrimination claims for applicants from employment as well. We'll talk a little bit about that, but this is really something to make sure you're covering at work. So discrimination and hostile work environment, we'll talk a little bit more about what those words mean, and harassment. It is not illegal to be a jerk or to be rude to people, to make them cry. It's not illegal to bully. Those are all things for a lot of other reasons, you don't want your supervisors or other employees engaging in. But what makes that type of conduct illegal is when someone is engaging in that conduct against an individual because of their protected class membership. That's what makes it discriminatory. So if you have someone who's picking on another employee because of their race, their religion, their marital status, their gender, that is what makes it discrimination. Most of these that you see listed on here, and the most common ones are the race, ethnic background, religion, gender, and age. Those, with the exception of age, they're equal opportunity. They apply to every single person on this call. It doesn't matter if you're white, Black, Christian, Muslim, male, female. We are all protected from discrimination on the basis of our race, our religion, our gender. There are some protected classes that just protect certain types of people. Age, you're only protected if you're 40 years of age or older. A veteran is only protected from discrimination based on being a veteran if they were favorably discharged. Other disability is a very common protected class. Obesity, recently in a recent court decision, was determined to be a disability. There are certain situations when it is okay for an employer to discriminate based on a protected class membership, and that is called a bona fide occupational qualification. So let's say you're a public utility and you are hiring for a line worker position, and this employee is required to regularly climb a utility pole. And you have someone who applies for the position and they come into their interview and they're in a wheelchair and they can't use their legs. You want to not hire them because of their disability. You decide, I really can't hire this person because they have this disabling position, so or condition. So is that discrimination? You would start the analysis and first say, yes, it's discrimination. You're taking an adverse employment action against them because of their disability, which is a protected class. However, you would qualify in this case for an exemption because it is a bona fide, it's a legitimate qualification of the job that you be able to use your legs. So those are few and far between, a bona fide occupational qualification, but they're out there. They're, I wouldn't say they're common, but it does come up. But for the most part, general rule, you can't discriminate against someone because of their protected class membership. Different forms of discrimination, you can see them on the screen. It's really just any negative employment action. And that could be not hiring someone, could be firing someone, it could be any negative action in between, not giving someone a promotion, having harder evaluative standards, etc. Harassment is one type of discrimination, and that's unwelcome conduct, and conduct can be words or actions that's based on a protected class membership, like we were talking about earlier. We're not just talking about someone who's an equal opportunity jerk to anyone. We're talking about someone who is specifically taking negative action against someone because of their protected class membership. And their conduct is either enduring and offensive, or it's severe or pervasive enough to create an intimidating, hostile, or abusive work environment. There's not one single legal phrase that I hear misused more than hostile work environment. I work with lots of employers every week, probably, who maybe not every week, but every month, who get a complaint from an employee that there's a hostile work environment. And the very first thing I do is look at is, okay, is this based on a protected class membership? And often it's not. Often it's a situation where they've got a bully as a supervisor, and the employer needs to address that. That's going to cause problems for them down the road. It's causing problems for them now. So I don't mean to say that that's not significant and you shouldn't look at that seriously, but it's not legally, it's not a hostile work environment. It's something else. Sexual harassment, this has it's very similar to the definition of harassment, but there's the sexual connotation with sexual harassment. So it's unwelcome sexual advances or other types of sexual conduct that's either made explicitly or implicitly a term or condition of employment, or submission to a rejection of such conduct is used as a basis for the employment decision, or it has the purpose or effect of unreasonably interfering with work performance or creating an intimidating, hostile, or offensive work environment. What you really want to be concerned about with that first bullet point, made implicitly a term or condition of employment, that is why so many employers have a policy that says supervisors cannot have romantic relationships with their subordinates, because when that romantic relationship goes sour, the subordinate employee is going to claim they felt like they had to date or sleep with or whatever this supervisor in order to get a good performance review or whatever it may be. So it's really good to have those policies for that reason. It's not as important, I don't think, when the employees are on the same level or they're not being supervised by one another. Usually employers just require disclosure of the relationship, but they don't have a rule that prohibits that.
Hey, Jordan.
Yeah.
There seems to be a few questions that have trickled in, and I want to
Great.
make sure that you get a chance to respond as our time might run
Yes.
short. So not specifically to that slide, but I'm seeing a lot of questions, or a few questions, about COVID vaccine requirements with medical or religious exemptions.
Oh, okay.
So I didn't know if you had some thoughts on that that might help the group here.
Okay. Let me wrap up the discrimination section, and then we'll stop there, and then we can transition to COVID.
Sounds
Is
good.
that okay? Okay.
Yep. Mhm.
I won't read this slide. You'll have this. You can read these afterwards, but this is how you become liable for discrimination. If it's carried out by a supervisor, you're really likely to have some liability. If it's carried out by a coworker, you're liable if you knew or should have known it was occurring and you did not respond appropriately to stop it from occurring. So this is why it's so important to have a policy against discrimination and harassment, to have within the policy something that's very clear on how an employee reports, how you care, you want employees to report, and that if it is found that that you take reports seriously, whether that's hire an outside investigator to help you look into it or look into it yourself, and then that you take appropriate action afterwards. So having that policy and also having trainings, a lot of employers, kind of the rule of thumb is every 3 years, retrain your employees on discrimination and make sure new employees are trained as well. Okay, so I think I will stop there and then we can talk about the questions. So COVID and exemptions. So are the questions, what do we do if an employee is asking for a medical exemption or a religious exemption?
Yeah, I think, and also any thoughts you have on items that have come up in your space that you've seen, just repetitive issues there.
Sure. So one question I'm getting a lot is, are we covered? Is our business and our employees covered under this new mandate, especially like about healthcare workers? That is a very fact-specific question. So that is a good time to contact an attorney and ask and walk through your different types of positions that you have and to help you determine whether someone is required to get the vaccine or not. I can do that. There's lots of other employment attorneys out there as well.
Mm-hmm.
Generally, when it comes to exemptions, I can give, that's a little less fact specific. There are forms out there. That is probably something you might also want to get from an attorney, but I don't know if the state might be providing some exemption forms as well, some free ones. So that might be worth looking and see if they do that. My guess is they probably won't, but sometimes they do.
So Jordan, just to add to that, so the clarity for most folks, the question is, can employers require the vaccination? I think that's a question we had earlier as well.
Okay. Yeah, so you still have to make sure you always have this ability for the religious and medical exemptions. So if you do decide to require it, make sure that you have that exemption out there. But generally, employers, it's looking more and more like, the guidance from OSHA and other agencies is that employers can require. It is a little fact specific. If you got an employee who they work by themselves, they're really not a risk to the organization if they get COVID, then requiring it in that situation might not be a good idea. There does need to be a nexus to the workplace, that there could be some injury to the business if there was a COVID outbreak.
Mm-hmm. Okay. I don't see any additional questions right now,
Okay.
Jordan, but here's a great opportunity for you to kind of and as soon as I said that, there's another that popped up from Dana. I'm going to ask this really quickly, and then I think you have the opportunity to close with your closing remarks.
Great.
So there are docs available to help with med religious exemption for accommodations. I guess she's asking if there are documents that would help be a template for that.
Yeah, it would be good just to have like a streamlined form that you have employees fill out. And I don't know if there are free resources out there. I mean, I'm sure there are a plethora on Google. I don't know how good they are. If the state has any, that would be a good one to rely on, or asking your attorney if they've got a form that you can use.
Okay, well, I'm going to leave it to you, Jordan, to give your closing remarks.
Great. I'm not going to talk about the disability section. Was the last section, and I'm not going to have time to talk through that. The other, but this slide, interviews, prohibited questions, really take a look at that. I think if I had to summarize disabilities in one section, in one sentence, I would say stay focused on an employee's individual ability to perform the job rather than their disability itself. That is a common theme in disability law. I'm just going to go to leave benefits. This I actually anticipated I wouldn't get to talk about that. I didn't anticipate I wouldn't get to talk about disabilities, but there are required leave benefits you must provide to employees. I've listed those on the checklist. We didn't have time to talk about them substantively, but they're on the checklist that Katie will be sending out in the thank you email. If you have questions about those leave benefits, feel free to give me a call or an email. My email address is on here. So thank you very much. Those were such great questions. Feel free to keep the conversation going with me if you'd like. Thanks for having me.
Awesome. Thank you, Jordan. I think what we'll do is attempt to bring you back to dig deeper into some of these things if we have an opportunity. And then maybe, as you mentioned, trainings here, maybe we can find some way that EASC can work with you to do a more formal training for our business community. So I think that would be great. So thank you, Jordan, for a great presentation here. It is an awesome thing to have someone provide that information. And so in solidarity, we raise our coffee cups to you, Jordan, for a great presentation. There it is. There it is.
Thank you.
Okay. And in other news, drum roll, we actually have our summer networking event this week. It is August 26th, which is Thursday, I believe, and it is actually from 4 to 7 p.m. It's outdoors. We will be following and adhering to all health responsibilities and restrictions to make sure that everyone is safe. It's at Echo Falls Golf Club. And guess what? We'll be unveiling and providing some swag from our new brand effort. So you'll have to say farewell to these colors that you see here. But really want to thank you all for being participants. It looks like we do have a hand raised before I wrap up here. Really quickly, next Tuesday, August 31st, we're going to actually have the rural projects effort, which will be at 8:30 a.m. coffee chats. But David from Port of, lost you there. Let's see. David Preston, if Katie, if we can let David in.
Did not mean to raise my hand. Sorry about that, but good job, Jordan.
Oh, okay.
Sorry.
That's awesome. All right. Another shout out to you, Jordan. So again, coffee chats next week is actually Rural Projects, August 31st, 8:30 a.m. Be there, be square. Really thank you all for joining us. Stay safe. Continue to look up the information that Jordan provided to us and reach out to her with additional questions. This has been another great coffee chat with Economic Alliance Snohomish County, and I wish you all a great Tuesday. Take care.